Hello, Mr. Needham.
Good afternoon, Judge.
Okay. Are we ready to bring Mr. Rogerson in?
That would be fine.
Okay.
Okay, we are live on YouTube. We are also recording this Zoom. Today, this is the South Bend Municipal Court coming into session. I'm Judge Christopher Bates. I'm filling in as pro tem judge on a few matters that are conflict cases. And the first case I will call is City of South Bend versus Joseph Rogerson.
Your Honor, that matter comes on this afternoon for entry of plea. The court should have in front of it a statement of defendant on plea of guilty, which I have reviewed with Mr. Rogerson in full. He understands the terms and conditions of that plea, what rights he gives up, what charge he's pleading guilty to, and what the prosecutor will recommend. My understanding in conversations with Mr. Duncanson is that the city has a recommendation in this case. We may have a slightly different view, and just in terms of the electronic home monitoring and so forth, and that's why we provided the declaration in terms of expenses and costs. So we would ask you to go through his statement of defendant on plea on the reckless driving charge and then move to sentencing today.
Okay, and is there a motion from the city to amend?
City moves to amend the charge of DUI to reckless driving.
Okay, and Mr. Needham, you're waiving a formal reading of that amendment. You're agreeing to the amendment, and your client wishes to proceed on the amended charge?
That's correct, Your Honor.
Okay. Mr. Rogerson, can you state your full name for the record?
Joseph William Rogerson, sir.
Mr. Rogerson, I have before me a statement of defendant on plea of guilty. You are now charged with the crime of reckless driving. That is a gross misdemeanor offense. It carries a maximum penalty of 364 days in jail and a $5,000 fine. Do you understand that by pleading guilty today, you give up all the rights that you currently hold in this court?
Yes, Your Honor.
Okay. You understand the recommendation on page 2, section 6C is simply a recommendation. I don't have to follow that recommendation?
Yes, sir.
All right. You understand that conviction for reckless driving will result in, at the very least, a 30-day licensing suspension?
Yes, Your Honor.
Mr. Needham, there's one item on page 5 under little t. I did not see that box checked, and I did review Mr. Rogerson's history. Did you make him aware of the penalties for a plea to reckless driving under the DUI sentencing grid?
Your Honor, we discussed the fact that the ignition interlock device may be continued longer. That would be the only additional requirement, which is 6 months. He's had the ignition interlock installed on his vehicle since the outset of this case. So
Sure.
by and large, he's going to get credit for that time served. Although obviously there'll probably be arguments that it continue to stay on his vehicle today.
Okay. Mr. Rogerson, you understand that because you have prior convictions, a conviction for reckless driving could result in some additional ignition interlock requirements?
Yes, sir.
Okay. How do you plead to the crime of reckless driving?
Guilty, sir.
And is that a free and voluntary plea?
Yes, sir.
Okay. And Mr. Needham, the document I have is apparently been signed by the defendant. However, it shows a large dark box, but I can barely make out a signature. Additionally, I don't see a statement of facts. Can somebody give me a recitation of the facts?
Sure, Your Honor. as Mr. Rogerson and I discussed this case, the facts were, and obviously the city may have a slightly different view. The facts of the actual driving where Mr. Rogerson was seen getting out of the vehicle immediately after it parked was him pulling out of the driveway and onto the street. There were other reports of a vehicle that matched a description similar to his racing around the block. There was no license plate number given, no identification other than the driver was male. There were several reports of different colors of the vehicle. It's a Honda Civic. It's a pretty popular make and model. So I think here our basis would be to just enter this by way of Alfred plea, because there's certainly enough evidence if the jury believed everything that the city put forth, we could be found guilty of obviously the more serious DUI offense just based on the breath test reading alone.
Okay. Does the city have anything to add?
I believe that Mr. Needham hit most of it. As he indicated, there is some potential issues, which is the basis for the amendment.
Okay. And Mr. Rogerson, your plea of guilty, nobody's threatened you to make that plea, and again, it is made freely and voluntarily?
Yes, Your Honor.
Okay. Well, I'm satisfied with the facts that were just outlined on the record, and the plea is accepted. Are the parties ready to move on to sentencing today?
Yes, I do want to note that I had been in contact with a victim of a prior DUI that was hoping to make a statement today. I explained to her that that may not be the case and that the court may not allow that. I don't know if she is on Zoom. I gave her the Zoom info.
Is that Dorothy?
Yes.
She is on.
Okay, so I just wanted to bring that up to the court and leave it to the court's discretion of if you wanted to allow her to make a statement.
Okay. I guess my question for both counsel for the city and defense counsel is, I have before me Mr. Rogerson's case history, which is, in my mind, fairly extensive with alcohol-related crimes. I guess I question how a statement from a victim in a prior crime is relevant to the instant facts and sentencing in this matter.
So from our perspective, it's just, so she is not necessarily a direct victim. She is a family member of one of the, I believe they were teenagers that were struck in the 2017 or the earlier DUI. And
correct, and I'm familiar with that, and that was outlined in Mr. Rogerson's alcohol evaluation.
Mm-hmm. And she just wanted to make a statement to the court. It's not necessarily directly about that one, but just more or less from what I've spoken with her, it's about making sure this doesn't happen again and wanting to ensure that Mr. Rogerson, I guess, gets put on the right path and does get rehabbed from this.
Mr. Needham, anything you'd like to say on the record before?
Well, Your Honor, I would agree with the court, although I can certainly empathize with the family who lost children in that prior incident. And I've had extensive discussions with Mr. Rogerson about it. I just don't see where, unfortunately, under the law, the Victims' Bill of Rights here allows a statement to be made in this particular case on these facts. Certainly, if she were one of the parties involved in witnessing this incident, I don't think I would have any issue. But given the fact it's a prior incident, I think the court here doesn't have authority to hear her statement.
Okay. Let's do this. I hate to prolong sentencing, but if the parties, because frankly, I'm on the fence either way with making that decision, but if the parties arguing one way or the other can get me a simple briefing summary on that issue so I can make a decision, I'd like to set over sentencing to see if that's allowable or not. Frankly, I just frankly don't know.
Okay.
Yeah.
Okay. Well, with that said, sentencing is continued. Madam Clerk, when is the next hearing date?
January 6th.
Okay. Sentencing will be set on for January 6th. Mr. Rogerson, I do want to remind you, you have pled guilty and all your conditions that were previously in place still remain in effect. Am I clear on that?
Yes, Your Honor.
Okay. All right. Well, again, I apologize for prolonging this, but this is caught in the court off guard, and I want to be well versed before I make a decision on that.
Thanks, Your Honor.
Okay. And that concludes this matter. We will reconvene for sentencing as stated earlier on January 16th.
January 6th.
6th, sorry.
That's okay. Thank you.
Thank you. Is that your only matter today, Mr. Needham? I believe so.
That is my only matter, Your Honor.
Okay.
Thank you.
Okay, and then we have Mr. Quintner, who has appeared in a timely manner today. Thank you, Mr. Quintner.
Quite welcome, Your Honor.
And I see that you have a Richard Meyer.
Right. Is Mr. Meyer present?
The court does not have him on the docket.
Yeah, I didn't see him on the docket either.
Maybe I'm looking at an older docket from, oh boy, I printed out one from December 2nd.
Whoops.
Whoops.
We have Mr. Ed Taylor on right now.
Okay, let's go ahead and bring Mr. Taylor in.
Okay, this is a jury trial readiness hearing.
All right, Edward Taylor, can you hear me?
Yes.
Okay. Matter comes on today for readiness hearing for the jury trial. And I know currently we are set for January 16th. I've discussed this briefly with my court clerk, and it appears due to some COVID restrictions, the court has no proper facility at the moment in which to hold a jury trial. And Madam Clerk, do we know whether arrangements are being made, or what is the status of trial availability?
There's nothing from the Washington State Supreme Court at this time that's giving us any kind of dates as to when we might be able to have restrictions lifted. But as they stand right now, we cannot provide adequate space. So.
Okay. Well, I think we just have to keep this on track, and pursuant to the court rules, due to those restrictions, there's good cause to strike and reset the trial and set another readiness hearing. Should we do that January 6th and see where we're at with a trial date in February?
City has no objection to that.
Mr. Taylor?
I understand.
Okay. One thing I wanted to address with the city and Mr. Taylor is I did receive a set of jury instructions from the prosecutor today. Mr. Taylor, do you anticipate submitting proposed jury instructions?
I'll forego that.
Okay. Then we'll put the jury instructions in the court file. Do the parties anticipate any motions in limine? And Mr. Taylor, what I mean by that is parties prior to trial can bring forward motions on which they wish to potentially limit evidence, things of that nature. Does the city anticipate any motions in limine?
City doesn't anticipate any from our side, no.
Okay, Mr. Taylor?
No, sir. No, Your Honor.
Then I'm going to, hearing that from both parties, I'm going to close the filing of any more documents before the trial. We'll just set this again for a readiness hearing and see where things are at.
Much appreciated.
Okay. Thank you for appearing today, Mr. Taylor. That concludes your case today.
Thanks, y'all.
Okay. Mr. Duncanson, if you have the proper docket in front of you, if you want to call the next case onto here.
The next one would be Seth Tibbetts, which is Mr. Quittner's case.
Okay. Is Mr. Tibbetts present?
Yes. Yes, sir.
All right. And you are Seth Tibbetts?
Yes.
All right. Present today is both the city attorney, Mr. Duncanson, and your attorney, Jonathan Quittner. And what is the plan today?
Well, I had talked to Kelly, you want to talk about it?
Let's
Go
let
for
I'm
Mr. Tibbetts, let's let your attorney talk.
Okay.
sorry.
So, this is an old case, an old DUI and driver's license suspended case. It's about 4 years old, and Mr. Tibbetts has struggled to comply with the terms of his sentence. If I'm not mistaken, this was a stipulated order of continuance, and he has had mainly poverty-related problems that have held him up, and now health-related ones too, because there is a pandemic, as we all know. He has one lung, so that makes it difficult for him to attend groups and things like that. However, he has been laboring under the thought that he was required to fulfill the conditions in the state of Washington. I'm not sure where that came from. He is now in the state of Colorado, and he's in a place financially and geographically that he can get on top of what's required of him. I don't think that he's stringing us along, because frankly, it's harder on him to remain under the court's jurisdiction for about 4 years. And so we're asking, I talked to Mr. Duncanson about it, and I think we are agreed on this. I'm asking to give Mr. Tibbetts a month to see what progress he can make on his services in Colorado so that he can close them out. And if he has not made any progress on that, I'm sure the city would be looking at revoking.
Mr. Duncanson, anything you'd like to add?
No, Mr. Quittner covered it all, and as he indicated that we had spoken about this, and I do agree with sending it over a month and seeing where Mr. Tibbetts can get to in that time.
Okay, Mr. Tibbetts, you have a month.
Yes. Thank you. So I have to get into a drug and alcohol class and make sure that they contact you with everything, right?
I'm not telling you what you need to do, but your attorney certainly can advise you on that.
Okay. I want to make sure it's clear so I know exactly what I'm doing and what I need to do, so that way I don't.
Okay, this is not a conversation to be had on the record. That's a conversation for you and your attorney.
Yes, Your Honor.
All right, that concludes your case. We will reconvene January 6th.
Okay, thank you.
Thank you. Any other matters?
That was the last one on your docket.
Okay. Well, with that said, gentlemen, we'll see you next year. Have a good Christmas. Have a good New Year's.
You too, Judge.
That goes for Madam Clerk too. Thank you. All right. Bye.
Bye.
Hey, Lisa.
Yes.
Is Dorothy still on Zoom?
She is still in the waiting room, yes.
Is it possible for you to send her a message and just say,
I can only message all.
okay,
Unless I bring her into the session, I can certainly do that. We can talk to her directly if you'd like.
yeah, if we could. I don't want her to sit and Zoom
Sure.
the entire time.
Yeah. Okay.
Hi, Dorothy, can you hear me?
Yes, I can.
Hi, so the sentencing was continued to January 6th. We need to brief on whether or not we can let you make a statement.
Okay.
So January 6th,
At what time?
12:30.
And you'll let me know?
Yep.
And even if I can't make a statement, can I at least listen?
Yes, I believe we have links on YouTube, correct, Lisa?
Yes, we stream live on YouTube.
Okay. Okay, I'll wait to hear from you. Can I call you like on the 5th to make sure so it's not happening
Yes.
the same day?
Yep.
Okay, thank you so much.
Yep.
Okay. Will, we are on to your docket.
Okay.
I have the contested hearing. She is ready and available if you'd like to start with that.
That would be fine.
I'm sorry, I couldn't hear you.
That's fine, yeah.
Okay.
Hello, is this Kim Kuhn-Howe?
Yes, Kuno.
Kuno? Okay, thank you. Ms. Kuno, my name is Will Penoyer. I'm the judge for the City of South Bend Municipal Court. And I have you on here today that you are contesting a speeding ticket. Is that correct?
Correct.
Okay, so you're denying that it took place, correct?
Yes.
Okay, all right. I have reviewed the police reports. So I don't know what you want to say, but whatever you want to say on your behalf. I will tell you that the legal standard is preponderance of the evidence. So I think it's more likely than not, 50% plus a tiny bit that the offense was committed. I have to find that it was committed. So, but this is your opportunity to convince me. So I'm listening.
Sure. So I was driving through there and I know that the speed limit initially is like 55 and there was a big blue truck in front of me, like an SUV type older that was just billowing smoke in front of me. And so I did speed up to pass that truck when it was in the 55 because it was literally choking me out and it was going well under the speed limit. So I did pass that truck, and then I do feel that I did slow down into the next sections. And then into town, it goes to 25, and there was a red car that pulled out in front of me and then went even slower than the speed limit. It's either 25 or 30, but they went even slower than the speed limit, and I was behind that red car for quite some time, going all the way through town to the other side of the town. And then I got pulled over and told that I had been speeding. So if I was speeding, I don't believe that it was exactly in that case, but I was in the initial part attempting to pass that vehicle that was billowing, exhaust smoke from behind it. I haven't had a speeding ticket since I was the month after I turned 16. I've had a clean driving record for like 20 years. So, I just, I feel like it wasn't really, exactly how it played out.
Okay, so what direction were you going?
So I don't know the directions of the town, but I was coming from.
Wait, were you heading towards the Seattle and Olympia, or were you heading away from Seattle and Olympia?
Away from Seattle and Olympia down towards Oregon.
That would be south.
Yes. Okay.
I realize it changes. It's not always going north-south, but roughly speaking, we call that 101 south, okay? So you were going on 101 south. The officer says that at 6 o'clock, he was going north on 101 in Jefferson, and he says he saw a black Kia Sportage that appeared to be going faster than 40. He received a digital readout and caught up with you at Kendrick Street. Now, Kendrick Street's right about in the middle of town. Was it right by the gas station, right? You were pulled over. Does that sound about right to you?
I don't remember a gas station. I can't say for 100%. If that's where he said he pulled me over, I don't remember. I just know it wasn't very far.
I'm just trying to get a sense of where we would.
Yeah. I just know it wasn't very far. Once I pulled out from away from him, that then we headed out of town.
Okay. And when you passed the vehicle, the truck, are you saying that was in a 50-mile-per-hour zone that you passed the truck?
Yeah, I believe that mile per hour zone there is like 50 or 55, and then I think it's 55, and then it goes down after that.
Okay, well, hold on a second. I'm just going to look at something on the map real quick because I know where the speed limit markers are. Okay, so the area where the officer saw you going, where he got your speed at 58, is right about the point where it goes down to 40 miles per hour. It's right in it's kind of a transitional zone. So given that you were so close to that boundary and that you were passing, I'm going to cut you a break on this one.
I appreciate that.
Close call, but
yeah.
Please just be more careful in the future. And I'm going to find non-committed on this particular infraction.
Thank you. I do very much appreciate that. I feel like I try really hard to be careful, and I've made it 20 years.
Your history, the only thing I see is a cell phone use while driving from 2016.
Mm-hmm.
So that's it. Okay, thank you.
Thank you. I appreciate it. Have a great day.
Thank you.
Okay. Shall we bring in Judith Bird to finish up hers?
Well, you're very optimistic. Yes, let's give that a go.
Do I have paperwork on this case?
Hope so.
Okay. Did somebody send me a plea agreement on this or anything, an SOC or something?
Judith has it. What she has done with it, I don't know, because we need her signature on it.
Okay. Can someone tell me what we're doing on Miss Bird's case?
We're entering a plea. The charge was assault. If memory serves, the sentence that was agreed, recommended, is all the jail time suspended and a fine of $100.
All right, I just didn't get paperwork on this. I got paperwork on a couple others from Mr. Duncanson, but not on this one.
This one we had signed and sent. I have an email where I sent back the signature page of the JNS from like
a while ago, maybe.
Yeah.
Okay.
It was like November 3rd is when she signed it.
Oh,
so.
okay.
Oh, so then we have it and we can still send it.
Well, she's still not showing up. So I wonder if we shouldn't take another while this is processing.
I only have with my own signature.
We can bring her in by phone. She'll be on audio by phone.
Okay.
Hello.
Hello. I'm having a hard time.
Hi.
I'm hearing impaired.
Who is this?
That's Judy Bird.
Oh,
Judy
Judy
Bird.
Okay. Hello, Miss Bird. Can you hear me okay?
Excuse me? I'm sorry, sir. I'm hearing impaired.
Can you hear me?
Can you hear him now?
Yeah, I could understand a little bit what you're saying.
Okay. Miss Bird.
Okay, I apologize.
Miss Bird.
Okay.
Can you please stop interrupting? I can't talk over you. Okay. Miss Bird, I am the judge for the city of South Bend. Can you still not hear me?
Please speak, help me. Yes, sir.
Okay. Miss Bird, I understand today that you are going to be pleading guilty to assault in the 4th degree.
Yes.
And that you've signed paperwork that you're pleading to assault in the 4th degree.
Yes.
Is that correct?
Yes.
Okay. And have you gone over that paperwork with your attorney?
Have you gone over the paperwork with your attorney?
Oh, yes. Yes, sir. Yes, sir.
Great. And you understand that by pleading guilty, you give up your right to trial, to question witnesses, the right to remain silent, the right to be presumed innocent. Do you understand that?
Yes. Yes, sir.
Ma'am, did you understand what I just said?
Yes, sir.
Okay. And Miss Bird, what charge are you pleading guilty to today?
What was that?
What charge are you pleading guilty to today?
Assault for, I guess. Assault for?
Okay, that's correct. And Mr. Quittner, what is the penalty in this case?
What is the maximum, or what is the agreement?
What have you guys agreed to?
We have agreed to 364 days all suspended, $5,000 fine with 4,900 suspended. That's my recollection.
Okay. So Miss Bird, you understand that all your jail time will be suspended and your fine is going to be $100, okay?
Yes, sir.
Okay. And Ms. Bird, I don't have to follow what they're proposing, but I most likely will. The maximum penalty is a year in jail and a $5,000 fine. And having heard all that, Ms. Bird, do you still plead guilty?
Yes.
Okay. No one's made any threats of any kind to you of harm or promised anything other than the deal you talked about?
No.
Okay, great.
Yeah. I don't know what he's saying. You're helping me. I apologize, sir.
Okay. Miss Bird, I'm just asking to make sure that you're making this plea voluntarily and that no one has threatened you or promised you anything on this. Is that true?
No.
Okay. And at this time, are you ready to plead? What is your plea to the charge of assault for?
Guilty. Right? Guilty.
Okay. And Miss Bird, what do you know what you were alleged to have done? Do you know who you were supposed to have assaulted?
What did you do to get in trouble?
I was disrespected and I slapped somebody.
Okay, that's good enough.
I also hand slapped him. I slapped him.
Okay, thank you, Miss Bird. I'm finding that you made this plea freely and voluntarily. I find that you know it was made knowingly, you know what you're pleading to, and I'm going to find you guilty. As far as sentencing goes, I'm going to do what the lawyer said. So it's going to be a $100 fine and 364 days in jail, all suspended. So at the end of the day, it's just going to be $100 and stay out of trouble for 24 months. Okay.
Okay.
Okay. Thank you, Ms. Bird. Do you have any questions for me?
No.
Okay. In that case, we are done. Thank you.
All right. Thank you. Merry Christmas.
Merry Christmas to you too.
Thank you, Judith.
Oh, no, I can't believe you gave me that.
Okay, Mr. Coma is on next.
Okay. All right. Still waiting on Mr. Coma's case. Well, can I ask you, gentlemen, I know we have to go over it again, but do we have a resolution on this case or not?
We don't have one ready to enter today, but we have agreed on what the resolution will be. I'm just going to ask to set it out 2 weeks.
Okay. So Mr. Coma, we just need to let him know that we're going to continue this and we'll get it wrapped up as soon as he's on. Great, thank you. So Madam Clerk, I wonder if we should move on to another one.
Let me see if I can chat him and see if he responds.
Yeah, you know what? I don't mean to be telling you what to do on that because technologically you understand it better than I do. Obviously, my goal is to keep court moving, as is yours. So
Absolutely. Okay, he is still not responding, so we'll put him back in the waiting room.
Okay.
Move on to Mr. Frienisberger. Frienisberger.
I just happen to know the family, so. Is this Mr. Primusberger?
Yes, sir.
How you doing?
Oh, not too bad.
Good, good. This is Will Benoyer, Mr. Primusberger. One of the attorneys, can you tell me what's going on this case?
Yeah, I've had a contact with Mr. Primusberger. We're pretty well settled on what we would like to do. It's just down to ironing it out with Mr. Duncanson. So again, I would ask that we set this one out to the next docket. I anticipate being ready to resolve the case then.
Mr. Duncanson, is that okay?
Yes, I'm fine with that.
Okay. Mr. Primusberger, this is not the most serious crime I've ever seen in the court. In fact, it's one of the least serious, and it sounds like you guys are working this out. So unless you have something to ask or contribute, we're just going to continue this to the next court date, which is January what?
6th.
January 6th.
That's fine with me.
Okay, then talk to your lawyer and we'll get her done next month.
All right. Thank you very much, sir.
Merry Christmas.
Merry Christmas. Yes, you too.
You too.
Okay, and Miss Odom is on now. Bring her in.
Yes. Hello?
Hello,
Hello.
this is Will Penoyer, judge for the city of South Bend. This case is on for, I guess it looks like a trial readiness hearing. Is that correct, attorneys?
Yeah, we had talked about, I mean, from my perspective, that, you know, Mr. Duncanson had not made contact with the alleged victim. And the thought that I was pushing it toward was, if we were not deemed to be ready today, then I would ask that the case should be dismissed.
That sounds okay by me.
Okay.
Well, yeah, I'm you, so.
I'm the victim. Hey, I'm the victim. If I could take a lie detector to be like my.
Alyssa, don't talk about the
Oh,
case.
pardon me.
No, you're fine.
Pardon me, hon. But I could prove, you know, beyond a reasonable doubt.
Miss Odom, please just stop talking for a moment here. You're not in trouble, but
Okay, sorry.
Shoot.
Okay.
Okay.
Yes. Okay.
Mr. Duncan, what is your response?
Well, I would say that the police reports do show probable cause and that it shouldn't be dismissed. I do know we can't go to trial right now, as we just had discussed this with Mr. Taylor. We don't have the facility to do trial.
Okay. However, Mr. Duncanson, and certainly there's no formal motion before the case is dismissed for NAPSTAT or something like that. But what I do want to know, I mean, is there a plan to resolve this somehow? I mean,
Really, is that for Mr. Duncanson? I'm sorry.
Yeah, that is for Mr. Duncanson. I know what you want, Mr. Whitner.
So I definitely would be open to resolving it with Mr. Quittner. Probably a little shy of just outright dismissal. But
I appreciate that. Have you had any luck getting a hold of the alleged victim?
I'm sorry, what was that?
Have you had any luck getting a hold of the alleged victim?
I've not. I've tried calling a couple times over probably the last month and haven't been able to get a hold of anyone.
Okay. Well, at some point, that's obviously an issue for trial, although I realize the same pressures for trial setting are not necessarily pressing on us right now because of circumstances. I guess all I can say is I would encourage the parties to try to reach a resolution, and Mr. Duncanson, if you're going to make a decision, to do it soon.
Yep.
That's all I guess I can really say at this point. Am I right? Is that correct, Madam Clerk, that we can't set a trial right now?
We cannot, we don't have the ability to accommodate with a facility, the mandate.
Facility, then I'm fine with this. Pause to not set a trial now, but I don't want to bump this out forever. Should we come back on the 6th or later in January?
Sorry, what was that?
Should we come back on this case? When are we going to come back on this? On the 6th or later in January?
Let's set it for the 6th, and I'll talk with Mr. Quittner, try one last time to get a hold of the victim and see what we can do.
That would be great. I'd appreciate it, guys. Even though we can't set trials, we don't want people dangling forever either. So
that is my thought. You're on the same.
Okay, Miss Odom, thank you for being on, and talk to your attorney, okay?
Okay, thank you.
Have a great day.
Yeah, bye.
That's a challenging situation.
So we have Ms. Rios on next.
Yes. Good afternoon, Ms. Rios.
Good afternoon.
As you know, I'm Will Penoyer. I am the judge for the city of Act. And work is on today for a pre-trial on, I believe it was a violation of a no contact order case.
Yeah.
My understanding is that the parties are resolving this today, but I don't have the full plea agreement. I simply have the signature pages. So you guys will have to edify me as to what the actual terms are.
Bring that up. My understanding, my recollection of this is that all the jail time is suspended. This is charge of a violation of a no contact order. All jail time suspended, so 364 days, 364 suspended, $5,000 fine with 4,700 suspended. I don't believe that we included any provision for staying away from the alleged victim. There's already a court order and a superior court case. We're trying to make this simple for Ms. Rios to plead to and be done with before her other case is resolved in superior court.
Okay. So what, she has another case in superior court?
Yes, with the same alleged victim.
I'm sorry, is it a protection order case or a different case?
It's not a protection order case.
But she has a different case pending in superior court, a criminal matter with the same individual.
Yeah.
It's my understanding the superior court case is where the no contact order is from. And that's still.
Okay, so it wasn't like he went up and got a no contact order by himself. It was part of a case.
Yeah.
Okay, obviously, you know, people can petition for those separately, so. All right, okay, so what's the probation gonna be on this?
1 year.
Okay, it could be up to 24 months or 12 months. It's up because it's a gross misdemeanor, so it's up to you guys what you want to recommend.
I would recommend 2 years, but.
Well, that's pretty conventional on something like this. All right, so Ms. Rios, you understand what's going on today?
Yes.
All right, and you're going to be, it looks like you are going to be pleading guilty to violation of a no contact order, correct?
Yeah.
And I don't have a statement of defendant on plea of guilty in front of me. So can you just tell me in your own words what it is that you did?
Well, I did not know that there was that contact order because he never did it himself. So I thought there was no contact order. That's why we were together that day. But I was not aware of it. That's why then we got pulled over and I got arrested. But it was just because I didn't go and check myself. I just kind of took his word. And
so, Mr. Quittner, I guess I should inquire here. I think one of the elements of being guilty of this crime is that you had to be, you know, served with the protection order.
Yes, unless you were informed of it in court. And I was satisfied at the time that she had notice. I don't recall discussing this exact part of it before, but there wouldn't be a valid no contact order unless it had been served on her. So I don't know, I'm not her.
Well, that's true. So Ms. Rios, you weren't in court when it was issued? You weren't served with a no contact order?
No, they just told me, well, they did tell me that when I met with my lawyer, my David Hatch, he told me about it. But then I guess my the person that, well, I'm not talking to him anymore. He's like, I went to the courts, I signed paperwork
All
They
right.
can figure that out, and I
All right.
believe them.
Okay, fair enough. So you just didn't check on your own. I think that meets the elements here. I just wanted to make sure that we had a proper case here. All right, so Ms. Rios, you know, by pleading guilty, you waived the right to a speedy and public trial, the right to remain silent, the right at trial to question witnesses, the right at trial to testify and have witnesses testify for you, the right to be presumed innocent unless it's proved beyond a reasonable doubt, and the right to appeal a finding of guilt after trial. You realize you have very limited right to appeal if you plead guilty, and that the maximum penalty for this crime is 364 days in jail and a $5,000 fine.
Yeah.
You understand all that?
Yes, I understand.
Okay, great. And the prosecuting attorney is recommending $5,000 fine with 4,700 suspended, 24 months probation, all jail time suspended, 364 days. That means that if you have any legal violations during that 24-month period, the fine could go up and you could have jail time imposed. Okay.
Okay.
All right. Feeling all right? Look like you might have a cold or something.
Yes,
Yeah,
COVID.
I had the coronavirus.
Oh,
I just
no.
got tested yesterday. And
I'm really sorry to hear that. I hope. Are you?
Yeah, I'm feeling a little bit better, but the past 2 days it's been really bad.
Oh, well, I'm really sorry to hear that. You feel like you're comfortable proceeding today? You understand everything?
Yes, I understand.
Okay, great. I just want to make sure. All right. And so at this time, what is your plea to the charge of violation of no contact order?
Guilty?
Okay, and you made that plea freely and voluntarily?
Yes.
No one threatened harm of any kind to you or to another person to cause you to plead guilty?
No.
And no person made any promises to you to cause you to plead guilty other than the agreement of the lawyers?
No.
Okay. All right. So I reviewed, in this case, I've reviewed this with you. I think you understand what you're doing in this case, what you're pleading to, and what the proposed terms will be. I find your plea was knowingly made, and I find you guilty. Moving on to a judgment and sentence, I'll adopt the recommendations of Mr. Dunkerson. I realize they're basically joint except for the probation period. But it would just, the only difference really would be 24 months instead of 12, which I think is consistent with the law on these kind of cases. I know, Ms. Rios, you don't have a lot, you don't have serious criminal history over the years. I hope that this is a rare occurrence. I don't expect to see him here again. And I'll impose the terms as agreed and sign off when presented. And I hope you feel better.
Yeah, thank you. I hope so too.
And the clerk will contact you, will send you something to make payments.
Okay.
Okay?
Okay.
All right, get to feeling better, all right?
Okay, thank you.
Good holiday.
Thanks, you too. Bye.
Okay.
Believe it or not, that's the first time I've just had someone tell me they had the coronavirus during this whole thing.
That's scary.
Yeah, I mean, it's certainly not uncommon anymore. I just feel bad for her. I hope she feels better.
Okay, I have somebody on. I'm not sure who they are. I'm hoping it's Miss Walther. We'll bring them in and see. Hello?
Hi, who is this?
Hello, Melissa Walter.
Hi, Miss Walther. This is Will Penoyer. I'm the judge for the city of South Bend. And your case is on today for a pre-trial. I understand that the attorneys have reached an agreement in this case. Does that sound right to you, Miss Walther?
Yes.
Okay. And can one of the attorneys tell me what the terms you guys have worked out are?
Yeah, Your Honor, we have agreed to plead guilty to the charge of allowing an unauthorized driver. 90 days jail, all of it suspended, $1,000 fine with $850 of it suspended, so for a fine of $150. I think that's about it. I've advised her of all of her rights, been over it all with specificity and including immigration. I do believe she's doing it knowingly and intelligently, and we're ready to proceed.
Okay.
I had previously sent over just the signature pages, but I just sent an email with the full thing.
I see that, and in the future, I guess I think we should have the whole thing sent. That'll save me, figuring out all the details in between,
Yeah.
I appreciate that.
I didn't even think about that.
We're still
Signature
working.
pages.
We're still working this all out, Ms. Walter, is that what your understanding is, that you're pleading guilty today?
Yes.
Okay. And you understand that you're giving up certain rights when you plead guilty, which is the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed, the right to remain silent before and during trial, and the right to refuse to testify against yourself, the right at trial to hear and question witnesses who testify against you, the right at trial to testify for you, and those witnesses can be made to appear at no expense to you. You are presumed innocent unless you are found guilty beyond a reasonable doubt by a jury, and you waive the right to appeal a finding of guilt. The crime with which you are charged carries a maximum sentence of 90 days in jail and a $1,000 fine. I believe the prosecuting attorney's recommendation was stated as $1,000 with $850 suspended, meaning $150, and 90 days in jail, all suspended. So, and that would be under 12 months probation, I assume. So during a 12-month period, you would have to pay $150 and not have any other criminal charges. And if you comply with that, you are in good. So,
yes.
Just to be clear, I don't have to follow anyone's recommendation as to sentence. I can give you any sentence up to the maximum authorized by law, no matter what they say. If you're not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the U.S., or denial of naturalization pursuant to the laws of the United States. And this time you plead guilty to the crime of, I'm sorry, what is your plea to the crime of allowing an unauthorized person to drive?
Yes.
You have to say guilty or not guilty.
Oh, sorry, guilty.
Okay. No, you're fine. And you made that plea freely and voluntarily. No one's threatened any harm to you or to any other person to make you make that plea?
No.
No person has made any promises of any kind to cause you to enter the plea?
No.
Okay. And this seems a little bit silly, but I have to ask you to state in your own words what you did that makes you guilty of the crime.
I allowed my ex-boyfriend to drive my car knowing he didn't have a license.
You nailed it. I know that's why it seems like a silly question. You've been over all this with your attorney, correct?
Yes.
Okay, great. I find that you make your plea, you made your plea knowingly and willingly, and that you know what you're doing here. I find that you are guilty of the crime of allowing an unauthorized person to drive. As far as sentencing goes, I am going to adopt the proposed terms made by the attorneys. So you will be have imposed what we already discussed: $1,000 fine, $850 suspended, 90 days in jail, all suspended. That's pretty much the long and short of it, unless there's any other details the attorneys want me to tackle. Nothing else, gentlemen?
Nothing else.
Okay. In that case, Ms. Walter, do you have any questions for me?
Nope.
Okay, then in that case, I think we are done here today. I appreciate it. And have a good holiday.
Thank you, you too.
Okay, do we want to try Mr. Coma again?
Sure. Madam Clerk, one quick question since I'm still new to this. Do you want me to confirm their addresses when I'm doing these?
If they show up, I've got a good address because I've mailed them a notice. So if they're here, we're pretty good.
I'm just trying to make, if there's any way to improve, I always wanted to improve. So,
Thank you, I appreciate it.
all right. So that's all the GNSs I have, right? So all the people that are feeding today.
Here's Mr. Coma.
Is the volume up? I can't hear anything.
No one's talking.
Okay.
All right. Mr. Coma, can you hear me okay?
Yes, sir.
How you
Your
doing?
Honor. Or, sorry,
How are you doing, Mr. Coma? Okay?
I'm doing all right. How are you doing?
That's fine. So, Mr. Coma, we're here today for a pretrial on your case. I understand from talking to the lawyers that you guys have worked something out, but you need a little more time to go over the paperwork. Does that sound right to you?
Sounds good. Good to me. I'm not really sure what they work out.
Well, Mr. Whitner, is that correct?
It is, and it's what we talked about yesterday, Chuck.
Oh, well, you know, I got a little TBI going on, so.
Yeah. We'll go over it
Yeah,
again.
okay, I remember.
All right. So we're just going to set this on for January 6th. Mr. Coma, you'll just come back on the 6th and talk to your lawyer between now and then and get it all sorted out, okay?
Okay. Yes, sir, Your Honor.
Okay, well, in that case, Mr. Coma, that's all I've got. I hope you have a great holiday.
Well, I hope you do. I hope you have a great holiday, and I hope your mom and dad have a great holiday too.
Thank you. I'll relay that to them, Mr. Coma. Thank you.
Please. I expect to see them real soon.
Well, I hope you see them in a non-judicial setting.
Well, of course.
Of course. There you go. Okay, man. It's good to see you, and we'll talk to you soon. Okay.
Okay. Yeah. Have a great holiday.
You too.
Bye, Chuck.
Mr. Whitner.
Yes, sir.
Okay. So what do we do from here?
Well, you hang up and give me a call next week, okay?
You want me to hang up and call you right back?
No, you hang up, yes, but give me a call next week, okay?
Okay, next week. This time.
I think we made a date for Tuesday.
Okay, Tuesday. Okay, sounds good.
All right.
Thank you, Mr. Whitner. Yeah, great. Well, your holidays, have a great one.
You too. Yeah.
Okay. Goodbye. Bye-bye.
I think you can tell I have an alternative holiday.
Okay, the only two we have left are the two arraignments. The court has been unable to reach either one, and neither one has contacted the court.
Okay. So just so I'm keeping things straight, we did 3 pleas today, right? We did Rios, Walter, and the woman, Miss, I'm sorry.
Miss Bird.
Bird.
Miss Bird, right? So we did 3 today, correct?
Yes.
Okay, I just have a bunch of papers that have been sent to me. I want to make sure that I have it organized, right? So we have nothing else today then?
Just the arraignments.
And they're not?
And nobody else is on, so.
Okay, so the arraignments you said are not, you have no contact with them?
Mm-mm.
Okay.
I tried mailing both of them notices and have not received anything back, but haven't received response from them either, so.
Okay, so I'll go through those individually then. I've already read them and reviewed them for probable cause. So first off on Mr. Medina, he's not here today. And he was, I guess when he was given the citation, he was told to be here today. and he has not. So I'm going to issue a warrant. It's a fairly, as cases go, it's not the most serious. So I'm going to set the warrant at 1,000. Then, as to Alexander Neva, that's actually the exact same fact pattern, same situation. I think the two gentlemen were out that night together. Again, I find probable cause, and I will again sign a warrant for $1,000.
Okay, that's it.
Okay, Mr. Duncanson, do you have anything else? I guess he doesn't hear me. Okay. All right. Do you have
Cut
anything
out.
else, Jillian?
Nope, I think that is it.
Okay, I sent you an email on something else. Make sure you get back to me, okay?
Yep.
Okay, thank you. Thanks, everybody.
Thank you.